This time, I would like to ask all in the council chambers to turn off or at least set your phones to vibrate and all other electronic equipment. Today is June 7th, 2016, and the public hearing of the Stratford Board of Zoning Appeals will come to order. This is at 7:02, I believe. In order to hear these petitions advertised for this session, for those of you who are not familiar with our process, each petitioner or their designated representative will present their case to the board. And when they have concluded, the board members will then have an opportunity to ask any questions. They may have, and I will then ask if there is anyone who wishes to speak in favor of the petition or anyone who will speak against the petition. Please speak clearly into the microphone. After all the petitions have been heard, we will then recess to our administrative session. Interested parties are welcome to stay. However, only board members and staff will be allowed to speak at this time. Please be advised that clapping, shouting, or any other way of expressing opinions on the application is not allowed and will not be tolerated. Okay? Mr. Fredette, would you like to take petition number 1 off the board?
Yes. Petition number 1, 1700 Cut Spring Road, petition of Archidec of Central Connecticut to waive section 3.14 requiring a minimum distance of 50 feet from an inland wetland in an RS3 district. Hardship, location of pond.
I'm just going to advise everyone that we've been having some problems with the microphone, so make sure you give it a good 6 inches of distance, otherwise it'll pop.
Yeah.
You'll hear it.
Will this work?
Yeah.
Sounds good. Okay. Yeah, we've applied. Can you hear this?
Yes, I do.
I'm the contractor, and as the homeowner, we have materials that she brought.
Yep. Thank you.
I don't know if it's, this was really nice. I had a neighbor randomly come up to me and knock on my door and give me a letter of
Is it in favor or against? Take it. Take them.
Do you have your mailings?
Yes.
Got them? Okay.
Yes, all the notices that were mailed. We went through the process with the zoning, the wetlands department. Went through wetlands some time ago in May 15th, May 19th. We got a comment and review that it has been conditionally approved, and that the conduct of such activity, talking about the deck, is no greater than a minimal impact on wetlands and watercourses. Should the board decide to approve the subject applications, recommended special terms and conditions be met, and that relates to digging holes and making sure we don't have any dirt that moves toward the pond. So it's pretty straightforward stuff. We're modifying, and I think you've all seen the plan, or at least the plot plan that shows that we are essentially adding a section to an existing deck. Pretty straightforward stuff.
the wetlands permit. I don't know.
Give it that handsome young gentleman over there.
Is this a copy?
It's not. Do you want me to make one and get it?
She just has the original, Jay. Do we,
Oh, your copies? It's just the wetland.
if you have a copy of the wetland, I'll take that.
We do have an original copy in the file. Or we have the copy that's been sent to us from Conservation.
Can I see that? Yeah. This is the,
Here, this explains just all the supporting documents that you've probably received copies of, talking about their process and what they've done. So, be happy to hand this off to you, but again, I didn't make a full copy of
Can
it.
you make a full copy? Is that something you want to enter into an exhibit?
Do you have a copy of
I do. I have this.
They give you the full document?
They gave me the full kit and caboodle.
Go for it. Okay. And as I said, you already have, you should have in file the plot plan that shows how it relates to the property. Yes? No? Okay. Questions?
Any questions, guys? Ms. Young?
Good evening. The plan that I have has a title of Revised Alternate 1. Is that the same plan that you are speaking of?
I believe.
The reason I inquire is I was curious, did you explore other alternatives that would not have required a setback variance, or do all points put you in the encroachment area of the wetlands?
May I see what you are referring to? Oh, yeah. This is, we didn't do this. This is from the.
Please speak towards the microphone.
This is from the, this is from the town records that we then took and made notes on. So when it says revised, it was revised years ago, not us.
I don't think, perhaps this is questions for Mr. Bansky, that I have what I guess they're referring to then. I have this revised alternate 1. Is there other plans that we should be looking at?
The plan that I haven't seen what they've given you here.
No. This is the one that we got from the town, and it said the revised alternate. We didn't make that remark on there.
So just
That's
to
the
confirm,
plot.
this
That's
is
the
the
plot
plan?
as it exists. Yes.
Okay.
Yeah. There is no other alternative.
So back to my question.
Yeah.
Forgetting the label on the plan, my question was, did you look at any alternatives that would have negated the need for the setback relief, or do the wetland locations necessitate setback relief in one form or another to allow for the deck?
We tried to minimize the impact, and the fact of the matter is that if the wetland rules were followed directly, the house couldn't be built. I mean, the whole thing's out of compliance. It has been. So the lines would have been halfway through. In other words, we couldn't have done anything to improve this deck, which exists right now. We're essentially adding this chunk right here to it. You should have this in your file. There's nothing we can do to make this large enough to actually use that wouldn't have impacted. All of it, up to including the house, is over the line. So that's why we went to the wetlands a couple of months ago.
Thank you. Follow-up question, if I may. What are you doing to accommodate stormwater runoff? Are you putting any crushed stone underneath the deck, or some way to mitigate the runoff from going directly into the wetlands?
The way we build, we don't use concrete piers, so we don't dig holes. We drill steel tubes into the ground with helixes on the bottom. They're called helical piers. So there's no change to the landscape at all. And the deck is 9 feet in the air, so the rainwater's been falling there for umpty-ump years. It's going to continue to go through the deck and fall right where it was. So we're not changing the impact from rainwater at all.
I have no other questions. Thank you.
Any more questions? Mr. Hoydick.
Just the type of materials you're going to use on the deck?
It's the framing material is pressure treated framing.
Pressure treated?
Yeah, by
Okay.
code.
Stained,
Yes.
I would assume?
Yeah.
Okay. Minimize the effect of the staining to leach into the, minimize the effect of the staining to leach into the pond, I would
No,
assume?
it's not going to leach at all. We stain the verticals, the columns, and the faces of the beams, and that's it. The rest of it's natural. The decking itself is composite material. Does not.
Oh,
Get
so you're going to
stained.
use composite?
We're using composite materials.
Okay.
We're using iron rails that are prepared in the factory, so there's no
Okay.
on-site impact from stains.
Yeah, that's no problem.
Yeah.
Oh,
Okay, any more questions?
I do.
Oh, good.
Can I have your name, please?
My name is Phil Brown.
What is
Phil
the last name?
Brown.
Bill Brown.
Brown. And your name?
Amanda Wolfert.
Okay, thank you. Thank you. Would anybody like to speak in favor of this petition? Would anybody like to speak against the petition? Hearing none. Oh, Mr. Fedett.
Motion to close?
I have a motion to close by Ms. Fedett, second by Ms. Young. All in favor?
Aye.
Aye. Thank you very much.
Thank you.
You can
Ms.
go-
Young,
you can go relax. We're going to vote on it this evening, but not till after we hear all of the other petitions. So if you want to hang around an hour.
Ms. Young, would you like to take petition number 2 off the table?
Taking petition number 2 off the table, 27 First Avenue, petition of Stratford Office Realty, LLC, to waive Section 4.2, requiring a maximum lot coverage of 25% to 27.68% in an RS-4 district. Hardship, plan to utilize 27 First Avenue as a permanent residence as opposed to a summer residence. Phyllis Satine, an artist, requires a northern light studio. The proposed addition offers the only northern light on the site.
Certificates of mailing?
Yeah, good evening. We would like to increase coverage.
Can we get your name?
Please
for the
state
record?
your name.
I'm Joseph Satin for Stratford Office Realty, who is basically my wife. We would like to add a 270 square foot elevated room with northern light exposure to be set on the right side, at the north side of the house, which is the right side as you face the front. The room would be set on galvanized steel piers. And as said, it would be about 270 square feet, 15 by 18. We had a request from the department to do plantings underneath the elevated structure. That's not a problem. We will do that. The construction will be similar to the other work that's being done, which is basically wood frame and windows.
Any comments from staff?
There are no other additional comments other than the staff review that was conducted on May 19th.
Okay. Okay, any questions? Ms. Young?
Good evening. The variance you're requesting, if I'm correct, is for coverage?
Yes.
And other than the desire to have the northern light, is there something unique about the property, in your opinion, that allows this board to grant you a variance to be in excess of the allowable lot coverage, such as an undersized lot or something other
Well,
than...
it's a 10,000 square foot lot, 10,000 plus. We're maxed out at about 100% of the allowable coverage, and what we're requesting is an additional approximately 2.5% coverage of the property.
I don't want to put words in your mouth, but I'm trying to just get on the record whatever hardship argument you are making that can be recognized under current case law. And my understanding is that personal desire for something that the zoning regulations don't allow is not sufficient to justify the granting of a variance, which is why I'm trying to explore the peculiar characteristics unique to the property that might...
Yeah, this is the only place we can put northern windows.
Thank you.
Okay, any other questions? Okay, thank you very much.
Like, the Planning and Zoning Office did receive some letters in regards to this application in support. I would just like to pass those around. Commissioner Fredette, if you could please stamp those in. Thank you.
If the chair would allow me to ask a question, Mr. Hibansky.
Yes, go ahead.
We heard the applicant identify the property as 10,000 square feet in size. What is the minimum lot size requirement in this zone, if you could remind me? RS4?
RS4.
gentleman to my right is thinking maybe 7,500.
I believe it's 7,500, but let me just double check here.
The answer to that question would go to my prior question about, is this a undersized lot? And it would appear the answer is no, if in fact it's 10,000 in a 7,500 square foot zone.
It is, the minimum lot area is 7,500 square feet, and the maximum building coverage allowed is 75%. 25%, I'm sorry, correct, 25% maximum impervious surface is 75%.
Thank you.
Okay. You're welcome. Would anybody like to speak in favor of this? Oh.
Good evening. My name is Wayne Garrick. I'm an architect, and my office is located in New Haven, Connecticut. We designed this addition. I would agree with Ms. Young that this is not an existing non-conforming lot, therefore undersized, but that with the, and I know this doesn't go to necessarily the strict interpretation of the hardship, but with the values of the property, and in as much as the owner has decided that they would like to make this their full-time residence, and that both Mrs. Satin and Mr. Satin are both artists in different ways. He a musician, she a painter. The need for this additional space, which is minimal, it's less than 3% of the existing lot, it really doesn't impinge upon the overall quality, and I think it still maintains the nature and the spirit of the town and the zoning regulations that we're abiding by. Just as importantly, everything else about this house does conform to the lot. We're not asking for any setback relief. We've worked within the setback. We don't need any height relief and any other aspects to the zoning other than a very, very small percentage of just over 2.5% of relief.
If I may ask a follow-up question of you, sir?
Sure.
As the architect of record, did you explore if something could be removed to compensate for this increase so that you ended up with no net gain?
Well, actually, the house has been a series of accommodations, for lack of a better term, since the Satins actually reside in Orange, actually in a very historic home, by the way, but they're in the process of transferring their permanent residence, sorry about that, from the home in Orange and moving. So as they've explored their needs for their lifestyle, as time has gone on, we've actually done a couple additions in the last several years, as documented by both zoning and the building department, all of very, very high quality, all to take advantage of the water view. And this is, in a sense, the final component of, in order to make this a full-time permanent residence. My apologies. I should know how far 6 inches is away.
It's not your fault. It's the system, so.
I don't want to be argumentative, but just because of the information you provided, I want to get my concerns listed on the record in case you wish to respond. What you've just described to me is that this owner, not some prior owner, consciously made a decision along the way to make several modifications, knowing what their coverage limitations was, and here they are asking for one more modification that exceeds what's allowed. Did I hear you correctly?
Not exactly, because I think this has been more of a project where things have evolved, as opposed to where there was a strict program laid out at one time and said, oh, we're going to do this, this, and this with a certain strategy. I think the strategy when we first began the project a couple years ago was to make this a summer residence, and clearly add a deck. We added a deck to the house. We expanded the living area ever so slightly to the house and created a study for Mr. Satin. So we didn't increase bedrooms. We haven't increased. The deck is really the portion of the house that takes up a lot of the square footage that we created. And as I said, this has been sort of more of a work in progress than a conscious effort to say, oh, we're going to approach this project on an incremental basis and then go before the board and ask for 3% of relief. I can assure you that that is not the approach that neither my office has taken for over 35 years of being in my own practice, or the Sattons, who have maintained several homes, as I mentioned, one very historic over the years of their very creative lifestyle, by the way.
Thank you.
You're welcome.
Thank you. Any more questions? No? No? Okay. Is anybody in favor, would like to speak in favor of this petition? Hearing none, would anybody like to speak against this petition? Okay, can I have a motion to close? Mr. Fedett, Mr. Hoydick. Okay. Oh, let's do this first. Okay, Mr. DeLuzio. We like DeCilio, I keep saying that. We take number 3 off the petition.
Okay. Item number 3 on our agenda is 65 Riverview Place, petition of Anna Lainez to waive 4.2, requiring maximum lot coverage of 25 to 28%, and the minimum front setback from 20 feet to 14 feet in an RS4 district.
Petitioner here. Okay, please state your name.
Oh, my name Anna Lainez. Oh, Anna Lainez.
Okay.
Okay, our petition is for a waiver for a setback in our front, and to make an addition to the side, and also build a garage, and on top it's going to be a bedroom on the back, where right now is our porch. And the reason for this petition is that the rooms are extremely small, and it has like an angle, and always we hit our head. Many times I hit my knees while I'm getting off my bed. So that's the reason why we need to have this setback and the additions. The extra room is because we never have the opportunity to have our parents for a visit, and for them to stay over, not even overnight, because we don't have an extra room for them to stay.
Okay. Does anybody have any questions? Ms. Young.
Good evening. The board members received a comment from our Planning and Zoning Administrator, Jay Hibansky, dated May 19th, that was in the file, where he makes a suggestion for our consideration. And I'm wondering if you've seen that letter, or if not.
Yes, we do have that letter.
Wonderful. I'm going to reference a portion of that letter. Mr. Hibansky writes, the applicant could potentially remove a portion of the proposed driveway expansion along the western edge of the rear addition and the existing driveway to increase the pervious surface and encourage more natural drainage of stormwater. Could you respond to that recommendation as to whether or not you would implement that into your plan?
that will be like taking off the plan to build the garage and the bedroom on top of it?
That isn't my reading, but perhaps since the author is among us, we'll let Mr. Bansky.
Because I don't really, I'm not clear on that part.
Basically, as you drive down your driveway, and the paving is going to be going, the proposed paving goes directly up to the side of the house, along the driveway and into the rear. My suggestion in my comments was that as you pull past towards the rear corner of the house along the driveway, to keep some of that space as grass or a planting bed, so that a lot of the water that will be coming down off of your roof, and I'm assuming down your downspouts, so that does not run along the driveway and directly onto your neighbor's property. It's held onto the property.
Yeah, it's still, we do have the grass area. And also we have an old garage at the end of the property, of the driveway. And we also will remove that garage and build, do all that area as a lawn.
Does someone have a copy of the map that I can clearly show, just so we're clear? Thank you.
Yeah. We will remove.
Entonces lo que él quiere decir es que en vez de poner un driveway aquí, solo va a tener el lawn todavía. So, básicamente el pavement todavía ser hasta aquí.
No, the driveway will come all the way back to the rear.
Okay.
My suggestion was that this area here that you have shown as paving be used as either grass or plant to retain.
Yes, we can do that.
Entonces lo
We can
único
do
que
that.
él está diciendo es que esta parte, solo esta parte, tiene que ser algo más.
But this is the entrance to the garage.
No, the end of the garage is here. This is just a small portion.
Este solo es un... Pienso que ustedes solo querían algo un poco...
You look lonely over there.
The driver will come all the way
He likes the
straight.
peace and quiet.
But
Sitting
we
there with all his
have
friends.
This little line, that area as a grass.
Es una poquita cosa, eso es...
Yes.
Entonces, eso solo es una cosa pequeña.
Yes, we can, yeah, no.
Not
Thank you
anymore.
so much.
Why don't you just resign? You're done. Smart.
Usted no... Cuando ya...
Why is everybody resigning? Why take it long to begin with?
Okay.
Straighten out.
Okay, does anybody have any more questions?
I guess I'm...
Mr. Hoydick?
Just a quick question. Are you going to remove, maybe I missed this, are you going to remove the existing garage that's there? Are you going to take the old garage down?
Yes.
So that's going to go?
Yes, that's gonna go, and we're gonna plant grass also
Grass
there.
Okay, thank you.
Okay, anybody else?
Trying not to listen in, but can you tell us what transpired at the podium in terms of understanding by the applicant and any modifications she's now making to her request to incorporate your recommendation?
I basically explained that as we pull down the rear half of the driveway, and Commissioner DeCilio can pass around the plan that I have drawn a little crosshatch section where I've recommended there be some, that paving that goes directly up against the rear addition, that be proposed, or I'm recommending that the commission put a condition and that be either some sort of garden, some sort of impervious surface to retain some of the stormwater on the property.
But, Jay, may I ask you this question?
Sure.
You pull down this driveway, and the garage doors are going to be on the side. So you're proposing they drive over grass to get into the garage? Am I misunderstanding something? You go down the driveway, and the garage doors are going to be facing this way, and you're going to go into the garage, right?
The garage is all the way in the rear, is it
Yes,
correct?
yes.
The garage is all the way in the rear.
You don't go all the way and come in and back this way, do you? There's no
Oh,
driveway.
it's straight from,
It's an L.
Yeah, it's an L, so the garage doors are going to be facing this way.
Yes.
So if you make a grass area in the hash marked area, they're going to have to drive down a paved driveway and then go across lawn to get into the garage.
Well, maybe I've misunderstood what was happening. I was under the impression that the garage would be at the end of the driveway, all the way at the end of the driveway. That's not the case?
no, the old garage is all the way at the end of the driveway.
Pass that back to Jay.
Yeah,
I see. I got it.
Yeah, so maybe they can make a little bit of this here and here, but it has to be the width of the door.
Sure, enough to leave space for the cars to be able to pull in.
Oh, aquí va a estar la entrada. Entonces, ¿por qué no lo hacen aquí?
As a condition. Well, if the board accepts.
Jay, did I ask a question?
Certainly.
If you have a concern about runoff, which is a concern for the neighbor, could we suggest or require a graded curtain drain in front of the garage door to collect the water that could be channeled to the backyard so that the water wouldn't collect against the garage door, yet it wouldn't drain into the neighbor's yard? Could we make that suggestion, or?
You certainly could make that suggestion. In all honesty, I don't feel that the drainage is going to be a huge issue.
No, I understand, yeah.
I just thought that it might be something that, if we can prevent any of the runoff by suggesting some more impervious surface, that we could. So I would leave that up to the board if they decided
Okay,
to do
all
so.
right. Thank you.
Okay. Any more questions? Ms. Young?
I'm just trying to understand where are we now with this. So you talked with the applicant at the podium, you marked up a plan. We've now learned more about where the garage addition is. Do we have a plan that identifies, if we were so inclined, where you recommend pervious surface be, or is there some square footage that we could add as a condition, such as, find 200 square feet and make it pervious, or something, some guidance you can offer us at this point?
I would actually take my suggestion off the table. I mean, I don't think it's necessary. I think that there's already, let me see what the coverage is again here.
I think you've answered my question, so thank you.
3%. I think it's negligible to add any other impervious surface at this point.
Okay, any more questions?
I actually have
Go ahead.
two questions. So I looked at the survey, and am I correct in assuming that your lot is 50 feet wide across the front?
I don't know, 50.
My survey's here.
Did I say 50? 50 by 100.
Okay, and it looks like the depth is 111 feet on the side long. So, and this is this an RS, let me see, this is in an RS4 district, which of the last application we identified as being 70, thank you, Mary, for pointing that out. It's on right on the map, 7,500. So your lot is undersized for the current zoning, and that's why you're looking for a waiver?
Yes,
Okay, I just wanted to be clear on that. Thank you very much.
thank you.
Two questions.
Well, that was like 3 in 1.
Oh, okay.
Mr. Chairman.
That's it. Be efficient. We can get out of here early. Okay, any more questions? Okay, thank you very much.
Okay, thank you.
Would anybody like to speak in favor of this petition? Would anybody like to speak against it? Hearing none, do I have a motion to close? Mr. Fredette, Mr. Hoydick? And before we go any further, petitions number 4 and 5 have been withdrawn, so if anybody's here on those petitions, you don't have to be here.
You need a motion for to continue it, or have they just been withdrawn?
It's just been
Application has
withdrawn.
been withdrawn.
Okay.
Did they withdraw them or table them? I actually talked to the woman today. She happened to be outside when I was looking at the property. She said that she thought they were going to be tabled, so she
No.
could... No?
Withdrawn.
They withdrew them? Okay. All right.
Okay. Which brings us right along to petition number 6, and Mr. Hoydick.
We got it. Petition number 6, 1525 Broadbridge Avenue. Petition for Brian Sokup to waive Section 3.17 requiring a minimum setback for a pool from 10 feet to 5 feet to legalize the construction of a pool in an RS4 district.
Good evening. Here is the mail out. I do have 2 signed letters from other neighbors with their name and address and phone number for the board. They were unable to attend it tonight, but they did ask that I hand that in. And then here's also just a copy of the variance letter that was sent out to the neighbors. I'm here tonight to request a side yard variance. There's one portion of a side yard on our property that our property is a rectangle, but it's an offset rectangle, and there's a driveway, a garage, and there was a very large tree, and we'd like to request a 5-foot setback on that side wall so that we can legalize a swimming pool. The pool really has no other place in the yard because of the driveway, because of the way it comes in. If it was to be moved, or even if it was a smaller pool for that matter, it still would never have the 10-foot barrier or the 10-foot sidewall setback that it would require.
Okay. Is that it?
Yes, sir.
Okay. And does anybody have any questions? Ms. Young.
Good evening.
Good evening.
You gave us a plethora of materials.
Probably
Thank you.
much more than you needed, and as you can tell, it's my first.
For my own clarification, in your
Yes.
written statement, the longer of the 2 narratives you submitted, you give us a chronology of events up until today.
Correct.
And one particular fact piqued my interest as a planning and zoning official. You talk about the duration of time that this pool has been in existence in its location.
Yes, the pool has been there. It has been there for almost 3 years. It's about 2.5 years it's been there.
That was sort of my question. I'll defer to Mr. Hibansky, our planning and zoning administrator, but my understanding is there is the 3-year rule references Section 813A of the Connecticut General Statutes, which protects its location if a duration of 3 years has passed. And so I was curious if we had hit the 3-year mark.
I don't. It's very close. I don't have a definitive date of when it was there. I've Google mapped it in efforts to hopefully pinpoint it exactly, but unfortunately, I wasn't able to go back that far with a clear photo of the property. So I don't know that answer.
This is a follow-up to that question, so it would not be worthwhile to leave this hearing open to allow you to do further investigation to quantify that? You've already exhausted that effort, is that correct?
Actually, they were, and I say they in planning and zoning. Planning and zoning originally was using that 3-year mark, and I believe it's John, the planning and zoning official, came to my home, and once he actually saw the location and where it was, he felt, he agreed that it was the only spot that the pool can be in, so he did feel a variance just was the most sensible approach. So at that point, he stopped that proceeding to do the 3 years, and I was, comfortable just applying for the variance, thinking that that was the most sensible to do.
I may just, you talk about your relationship with your abutting property owner?
Yes.
Who had made the initial complaint?
Yes.
Has there been any further developments on that front, perhaps with respect to some meeting of the minds?
I have actually sent a letter and handed it to her personally and tried to do so, and nothing came about that from that point on. So no, nothing. In fact, the only other interaction entirely was I had to repair a part of my fence, and there's a portion that had a weak pole, and while I was doing that, she came outside and told me to get off the property, that I'm not allowed to be there. And I was only about a foot or two working on a fence that we have combined in the property, There was no other way for me to work on that fence, but I did put the fence exactly back the way I had it. I was off the property, and that was the last time that I have spoken with her.
I think you referenced that in your letter. Yes, that sounds like something I
Probably.
did. My last question, if I may. Are you in possession of a copy of the May 20th comments that Jay Hibansky put together, where he makes an observation at the end of his memorandum, I'll quote from it, "The pool could potentially be moved to a location on the property that would not require variance to section 3-17. Could you respond to that?
I am. Actually, I had called John yesterday because I was a little confused on that myself, and John had said that he was there, and John did agree that that pool couldn't really be moved anywhere else, but he said that those were Jay's comments, and I had to just address them the best that I can here, and that's really all that I can. I mean, the pool essentially could not be moved unless a driveway was to be removed or taken down, or a garage was to be removed or taken down, and ultimately that would leave it so the pool cannot be just moved anywhere, because a smaller pool, a different shape of pool, all of them, no matter what happens, I will still have a 10-yard issue for that setback on that side yard. We have plenty of distance from back into other side, but it's that one specific side yard because of the off-shaped rectangle that it goes down on. It is a rectangle, but it hugs a corner, or the way it goes down, there's no way for it to make that 10 feet anywhere as we go down. Even if the pool was to go farther down the property, it would always be at that same issue, that it could never make 10 feet.
Not to put you on the spot, Jay, but here I go again. Do you want to respond to this gentleman's suggestion that perhaps John of your office doesn't share the opinion as you wrote it in your staff letter?
I mean, yeah, I mean, no,
Many people don't share my opinion, but that's okay. No. Well, I mean, I think the applicant, it's tight. There's a lot going on in the property, but as the applicant said, without removing driveway, you can't do it. I think there's potential to move driveway, relocate some asphalt and shift the pool over. That wouldn't require a variance.
But with that said, and I didn't mean to cut you off, but when you say move driveway, that would be moving enough driveway where it would be impossible to park or pull into a driveway, which would basically eliminate the whole purpose of the driveway in a garage by itself. It wouldn't be like moving a foot or a two, or making an area that would allow that to happen and be able to park at the same time.
Last question.
Sure.
Because there is so much information provided, could you summarize for me again what is the hardship that you are relying upon
Sure.
for the granting of this variance?
The hardship is because of the way the property consists between everything that's back there, and it's a nice backyard, but because of the way it's designed, there's no way for us to legalize a swimming pool given a 10-foot side barrier. You're very welcome. Thank you.
Thank you. Any more questions? Okay, would anybody like to speak in favor of this petition? Would anybody like to speak against the petition? Please come forward.
Good evening.
Please state your name and address.
Letha Williams, 1521 Broadbridge Avenue, the property next door. I've lived at that property since 1998. That driveway was not there when Brian moved there. The pool was not there. I do have a variance I had to get prior to any addition on my property. The variance had to be prior. My concern is I've been complaining about this pool for 2 years. I had to come down here to the mayor's office to get them to go over there and investigate. It's been 2 years that this has finally come to fruition. That pool, what happens is when I am in my backyard, I am getting a backlash. The pool was not there. I have evidence and proof by other people who have cut my yard, my grass, and they will tell you that that pool has not been there for 3 years. My mother passed away in 2013. I had guests there. Brian was in Iowa, and that pool was not there. He had renters there. And if you look at the pictures, you can see just how close it is. He's opened the pool. These are pictures of with the pool closed.
You looking to submit these as evidence?
Yes. And he also has, in that pool, there's a jacuzzi there that is far enough away that if he wants to say, and that pool is on the pavement. He has had that yard paved just since he's been back. And that pool is infringing on my pleasure because if I'm out in my yard cooking on my grill, I'm getting a splashback. And I'm asking the town to follow the law. If the variance was not applied to before the item was put there, then it needs to come down. Thank you.
Thank you. Any questions, Ms. Young?
This question perhaps is for Mr. Bansky again. The pictures that we were just shown seem to have the pool elevation at the same elevation as the adjacent fence. Doesn't seem to be screening provided by the fence. That was just my quick perception. What are our allowable fence heights, and do we know the height of this fence? Could it be taller to provide more screening to this abutting property owner, to your knowledge?
Without a variance, the fence height maximum is 6 feet within, once you move out of the first 25 feet of the property. I do not know offhand the height of the fence. I haven't seen those photos yet, but
That's not 6 feet. It's a 4-foot fence.
It looks taller than 4 feet, but it's tough to tell from the photo I have here.
The question may be better answered by the property owner or the neighbor who have the fence in their respective yards. Would either of you think?
I'm assuming the wood fence is what you're talking about, but that is a 6-foot privacy fence.
Thank you.
You're welcome.
Come forward.
May I respond? That
Certainly.
fence was there when I moved there in 1998, and it was a part of my property. What Brian asked me to do when he moved there, because it was an old fence, if we could split the cost of replacing the fence. And if you'll notice there, the fence travels, one end is higher than the other. And because of the way the property goes down, it is not landing at 6 feet. I do believe because the law was not followed, the pool needs to come down. Thank you.
If I may ask the neighbor a follow-up question.
Yes.
If this applicant had modified or in the future modified their request to seek a variance to have a taller than allowable 6-foot fence and keep the pool in its same location, would that mitigate your concerns?
No, it will not. I prefer to have the pool 10 feet away from my property.
Thank you.
Thank you.
Okay. That, do we have a motion to close? Mr. Fedett, Mr. DeCilio, all in favor?
Aye.
Okay. Moving right along, we will start the administrative session.
Mr. Chairman, we may take a 5-minute recess?
Certainly.
Thank you.
Right.
Good. How are you?
the order at 7:54. Thank you for your patience. Mr. Fedett, would you like to take number 1 off the...
Yes, I take item 1, petition 1, 1700 Cut Spring Road off the table.
They got 1,700.
1700, what did I say? 700?
1750.
I need glasses.
Okay. You have a second.
I'll second that.
Okay. Any discussion? Ms. Young?
Was that a motion to approve? That was
No, this is take it off the table.
Off the table.
I guess I would like to make a motion to approve, and I'd like help perhaps from Mr. Hibansky as to how I might craft my motion to incorporate his recommendations that any approval be granted contingent upon the letter from Ms. Betch dated 4/11/16.
I would recommend that should the board decide to approve, it would be conditional upon strictly adhering to all the special terms and conditions and standard conditions outlined in the letter dated 4/11/2016 from the Conservation Department.
Okay.
The hardship being the location of wetlands. That's my motion.
And I'll second.
Okay, and we have a motion, a second by Mr. Fredette. I guess all in favor, but we have to put the stipulations in.
Yes.
Have to be noted.
Yep.
Okay. Do we have a vote on it?
Aye.
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 Aye. Carries unanimous. Okay. Ms. Young, 27 First Avenue.
Motion to take it off the table, or am I putting it on the
That's it. And do we have a second? Mr. Fredette. Okay, any discussion?
I'll start the discussion.
Okay.
I was searching, as you perhaps all saw, diligently to try to get something on the record that could justify action by this board to grant the variance to someone who I'm sure is going to be an asset to the community. And I couldn't find it, and the applicant, in my opinion, failed to offer it. We have a lot that's in excess of the minimum lot size. Had it been undersized, that might have been the justification warranted for coverage variance, but without that on the record, I don't see how we could justify the granting of a variance, and therefore I'm not inclined to do so. That's my opinion.
Okay, any more discussion?
Yeah, I looked at I drove by the property. It's a beautiful house, and they should be proud of owning it, but there is an expansive deck across the front, and the applicant really never considered, perhaps a smaller deck or any mitigation to, and there is no hardship that Commissioner Young just brought it up. I know, I collect art, and I think art's a wonderful thing, but just because you want an artist studio, there's nothing to the property that's causing a hardship that I can determine. So I concur with Commissioner Young and her analysis.
Do we have a motion to approve or deny?
Motion to deny for failure to demonstrate hardship.
Okay, do I have a second?
I will second that.
Okay, thank you very much. Okay, all those in favor to deny this?
Aye.
Okay, motion carries 3-2. Okay. So DeCilio, petition number 3.
I will make a motion to take 65 Riverview Place off the table.
Yep.
I'll
And
second.
do we have a second by Mr. Hoydick? Okay, any discussion?
I'll start the discussion.
Okay.
Not making a motion, just discussing. I was grateful to the commissioner to my right, DeCilio, am I pronouncing that correctly?
You did.
Thank you. Who got on the record on behalf of the applicant who didn't clearly get it on the record, that we are talking about an undersized lot seeking a minor increase in coverage, and that is the type of hardship argument unique to the property that was lacking in the last application, in my opinion. So that gives me better reasoning to support someone else's motion, should perhaps Commissioner DeCilio want to make one.
Okay, any more discussion? Yes, Mr. DeCilio is on the spot to make a motion.
I will make a motion to approve the applicant for 65 Riverview Place, petition of Anna Lanes, for a waiver.
Okay, we have a second by Ms. Young. All those in favor?
Aye.
Carries unanimous. Okay. Mr. Hoyter, petition number
Yes,
6.
our item 6, 1525 Broadbridge Avenue, petition of Brian Sokop to waive section 3.17 requiring a minimum setback for a pool 10 feet to 5 feet to legalize the construction of a pool in an RS4 district.
That's a motion to take it off the table.
Yes, that's a motion to take
We
it
have a motion. Do I have a second? Mr. Fredette. See you smiling over there.
Sure.
Okay. Any discussion? Ms. Young.
I, again, was trying to probe with the applicant what is the unique characteristic of the property that demonstrate hardship to support the granting of the variance. I thought I heard him describe that perhaps he didn't use these words, but the lot shape. But when I open up the survey, I'm seeing what looks like a regular shape to me. So I'm still in search of the hardship to support this. And until someone articulates it for me, I'm not inclined to grant this.
Well, I'd like to chime in on this. This is identical to, if we look at our minutes, which we're going to review and hopefully approve of last month's meeting, the petition of 225 Reed Street was identical to this. This particular lot is 52 feet wide. It's RS4, which we've already been on the record, that says it needs to be 60 feet wide. So you have a non-conforming lot width. At last month's hearing, there was a neighbor in opposition. We had much discussion about flooding and if the pool breaks and all that, you may all recall. What I would like to state for the record, and as commissioners, we need to really decide how we're going to handle these and I think be relatively consistent. That was a pre-existing pool. It was approved. This is a pre-existing pool. Do we stay with that mindset as a commission? I think consistency is critical here.
Not to be argumentative, but I would beg to differ that I don't think this board ever sets precedent, and I think it's a dangerous territory to be creating policy that we would put forth and apply on a uniform basis to individual applications, and I hope the town attorney will speak on that when we speak with him following the meeting.
Okay. Mr. Fredette? Have anything? I mean, a couple months ago, we did pass the one on Reed Street.
Right.
So I don't think we have any choice but to vote for this.
Well,
I respectfully disagree.
well, I will make
Well
a motion
taken.
to approve.
Have a motion to approve by Mr. Fredette. Do we have a second? No second. Okay.
Well, I will second Mr. Fredette's motion.
Okay, so we have a second by Mr. Silly. All in favor?
Aye.
Aye.
Aye. Aye, so it's 4 to 1.
Actually, I'm opposed to it as well.
Okay. Okay. It's 3 to 2. I said aye.
So it passes, right?
Mm-hmm. Pass 3 to 2.
You know, if we just could just carry that for 1 second, I think maybe some of the criteria we should use is opposition to a pool that's close to someone's yard. Had there not been so much opposition, I wouldn't have had a problem with it. But you have to take the consideration of the homeowners that is adjacent to a pool.
I understand.
I mean, if this was the same situation and everybody said everything's fine, we don't really have a problem with it, I wouldn't have a problem with it. But being in such close proximity and backyards are tight, that would be the main criteria that I would use from here on in, because there will be more of these that are going to come through.
I appreciate your getting that on the record, but this forum is not supposed to be, in my opinion, a popularity contest of how many people show up to oppose versus support. I think variances, if ever appealed, need to be demonstrated in a court of law that there is hardship found unique to the peculiar characteristics of the property, making it deserving of consideration for varying of the regulations, and that is incumbent upon the applicant, not this board, to put on the record to allow this board to grant them those variances. And telling us what they want is not the same thing as telling us why the property is warranting it. Thank you for your thought.
Well, thank you. Well, my thought is we passed something similar on the other end of town a couple months ago. And I don't want to start a legal battle with appeals and lawyers and this and that. I mean, what we do for one, we have to do for everybody.
I respectfully disagree and look forward to hearing
Well,
from the town attorney.
Everybody's entitled to their opinion. So with that, we have a motion to close.
Motion to
Mr.
close.
Fredette? Yep. Mr. DiCilio? Thank you very much, people. Mr. Floric, I hear you have some training questions for us.
Are you on the agenda?
I don't know. I hope.
Can I make a motion to add this discussion to our agenda if necessary?
Oh, yeah. I think we have a motion and second by Mr. Fredette.
Did you vote?
Yeah.
Yes, I did.
Aye.
Aye.
I've been asked just to say a few words to you with respect to the principles by which this board should operate, and I couldn't help but listen to the discussion that was going on. Let me just make a couple of points about that. Obviously, the biggest bulk of the work that comes before this board is variances, applications for variances. It's clear. Ms. Young is absolutely correct. There needs to be a hardship, and that hardship has to be peculiar to the piece of property that you're considering in the application. Because of some peculiarity with that piece of property that other properties in the neighborhood don't share, the application of the zoning rules to that piece of property would create an exceptional difficulty or an unusual hardship. That is the only way you can grant a variance. So, let me tell you some things. It's probably easier to tell you things that are not hardships. Financial hardships. A lot of times you'll have people come in and say, I have to be able to do this because I can't maximize the use of my property unless you allow me to build this, and I need this variance or that variance. Well, that's not a hardship. Financial hardships are not hardships. I had one that I had to defend, regrettably, where a guy came in and he wanted to build a room onto his house because he was taking care of his paraplegic war hero father. He needed a variance. Couldn't grant it because there was nothing in that land that made it, a hardship. He had a personal hardship, certainly a sympathetic case, but you can't grant variances for that.
Are you taking questions along the way? Should we say?
Go ahead. No, jump in.
If I may. You mentioned the last case you had to defend. My understanding is the case law is always accruing, and that citing ADA necessities is allowable.
That's a little bit different.
Substitution.
Right.
Could you expand on
They
that?
never claimed that in this particular case.
Had
And
they
it was
done so?
back a long time ago, too.
Had they done so, would you change your opinion?
There is a lot of law that you have to give a quote-unquote reasonable accommodation from the zoning regulations where it's warranted for medical is just one of the areas, but where it may be warranted in order to allow the applicant to enjoy the full benefits of that property on an equal footing with other people. So in general, yeah, the ADA does apply. And we did settle a case a few years ago with respect to a property that was being used as a, I don't want to say rehab center. It wasn't a rehab center, but it was like a house for recovering alcoholics. And they needed they wanted to meet in the shed. And in order to do so, it would have violated the zoning regulations. And so the ZBA denied it. They sued in federal court. Ultimately, we settled that case, allowing them to use that piece of property. So yeah, ADA considerations are important. But the reasonable accommodation has to be asked for. You don't make that determination. They have to affirmatively ask for it. And in the case that I mentioned, they didn't. We've had situations where people have been paying taxes on two adjacent or abutting pieces of property, but because of zoning could only use one. So they came in for a variance to do whatever they had to do to be able to utilize the second piece of property for building. Well, that's not. That is not a hardship. Increased revenue for the town. A lot of times you'll hear people come in and say, I'm going to put this in or I'm going to do that, and it's going to increase the tax dollars to the town. Well, that's not a hardship. That's not a reason for granting it. Mr. Dempsey, previous variances, unfortunately, are not reasons for granting it. So you might have granted 25 different variances for the same reason. If this lot doesn't have a hardship, it can't do it.
Mr. Floric, may I ask you a question?
Yes.
An undersized lot or undersized width, the shape of the lot itself, does that in itself constitute a hardship, or
it could,
or does it need to be that plus additional features, like for instance, driveways in the way, existing buildings in the way of?
I think the more additional features that you are able to develop certainly helps. If the only problem is that the lot is undersized, so that you can't build the size of house that you want on that lot without a variance, my guess would be that that's not a sufficient hardship.
Thank you.
But if you combine that with other features, like the location of a septic system, like the location of a driveway, like a slope, like wetlands, then it might be.
Were you planning, or may I ask you to speak to other opportunities for applicants to put on the record something that might substitute for the traditional hardship argument that would allow the granting of the relief requested?
What do you have in mind? Because under the law, the definition of a hardship which supports the granting of a variance is fairly narrow. Now,
I'll tell you what I mean.
Okay.
There's a line of cases, to my understanding, I'm not an attorney, that allow reduction in nonconformities, for instance, to substitute for traditional hardship.
Yeah, to a degree.
And yes, and my understanding is there's sort of some tests that need to be met. That not only does an applicant have to demonstrate a reduction in nonconformities, but also consistency with the plan of conservation development, neighborhood designs, and things of that nature. And I wondered if this isn't the right form, perhaps a primer of some sorts might be appended to the handbook that each of us are given upon our arrival to this board to help us keep up with the case law, which again seems to be more and more case law is growing in the world of ZBA, and E&F Associates is another case that I thought was of interest that perhaps you might speak to if this is the right forum.
Case law is constantly evolving. You're absolutely correct. And anything that can be developed and appended to guide you like that is good. And the law encourages the reduction of nonconformities, and that's clear. However, obviously the basic principle that has to be adhered to is the hardship principle. You can't, a reduction of a nonconformity without a hardship is not going to be sufficient to support a variance. You still need to find the hardship. And one of the things that sometimes what boards do is they'll consider a petition or several petitions, and they'll never once mention the word hardship during their deliberation. And when I noticed that you kept on doing it, and that's good, that's the right way to do it. You have to find a hardship. Now, I've told you what the law is, okay? Obviously, people, you want to do equity. You want to do fairness. You want to do equity. If someone comes and asks for a variance, you know, I have a swimming pool, and it's going to be a foot too close to the within the setback, so I can't build the pool I want. And they put on their petition, and nobody shows up in opposition. Human nature is, okay, big deal, we're going to grant it. You need to at least discuss the hardship in terms of lot size. The applicant couldn't put it there or couldn't move it because, you know, the deck is already there, or the lot is too small, or there's a rock sitting over there, whatever. But you need to get something on the record that deals in terms of a hardship. Otherwise, although if you don't state a hardship, the law is that the court has to search the record and see if anywhere in the evidence they could find one. Without at least discussing the hardship and trying to find a hardship, you're setting yourself up for an appeal being taken and that appeal being sustained by a court.
Are you familiar with the E&F Associates versus the CBA in Fairfield case?
No.
Perhaps at a later date, if you're willing and if I'm allowed to ask. That case created a ripple effect in the town in which I work. That case suggested that not only does an applicant have to demonstrate a hardship argument, but they have to demonstrate that somehow there's a deprivation of value, that somehow without the variance being granted, they could not maintain economic value of their property, which certainly makes it such that if we were to follow that line of thinking, no one would get a variance if they already have a home on their property that obviously would have some monetary value. And then I guess if there is going to be a legal memorandum, again, to update us on Supreme Court decisions of the state of Connecticut, the Adolphson case, Stancuna case, the Hescott cases, my understanding of reading all of those is that those do allow for no hardship to be demonstrated, but again, this reduction in nonconformities can be used as a substitute for hardship, and that can stand up in a court.
I would have to read those cases, but I would be surprised and shocked if what you say was true.
We were too when we read them, but we look forward to your read of them.
I have a question regarding appeals.
Yes.
Let's say we have an application and we discuss that there's a possible hardship, but we can't nail one down. How long does the appeal process extend to? How long could someone, an abutter, wait before they have to make the appeal?
No, that's a fairly rapid situation. It's 15 days from the date of publication of your decision. So they have to make that decision quickly. Now, as it goes through court, it could take a while depending upon how the case unfolds. Generally, from the time the appeal is taken to the time the case is actually heard, it's probably going to be a year in that area, 9 months, a year.
But if they don't file within that year?
Then, well, no, if they don't file within that number of days after your decision is published.
It's that short of a time?
It's that short of a time, yes.
Okay. All right. Thank you.
Now, sometimes boards condition the granting of variances, and you're allowed to do that. so long as those conditions are reasonable and so long as they are meant to accomplish a purpose that is commensurate with the zoning regulations. I'll give you an example. The one that was overturned, we used to do it a long time ago, but sometimes when a variance would be granted, the town would want to have the landowner, as a condition of granting the variance, give the town a right-of-way for road widening purposes or something like that, okay? Well, that you can't do that. We used to do that, and it was a good idea from the engineering department's standpoint that we could clean up a lot of things, but you can't do that because the condition being imposed had nothing to do with that particular application. And so you can't do things like that. We used to also in this town set a time limit on variances, that they could only last for a certain period of time. So if you got a variance and then you didn't apply for a building permit within a certain period of time, that variance was denied or revoked. Can't do that because variances, once granted, they run with the land. They don't run with individual property owners. They run with the land, okay? So there are certain things that you know, we used to do and the towns used to do that are not strictly done anymore.
I'm curious, not familiar with the procedures in Stratford. To your knowledge, maybe this is a question for Mr. Hibansky, do our procedures require that applicants file a copy of the resolution of approval on the land records so that, to your point, you know, if years pass, people forget that variance was granted, that any title searcher could find it on the land records should a future owner want to utilize that variance?
Yeah, we do. We do record variances on the land records.
And do those resolutions contain language, or would it be your recommendation that those resolutions contain language tied to a plan, so it's quite clear what the variance is granted for, you know, as shown on the plan prepared by so-and-so, dated such and such, so that a side yard setback variance demonstrated to a board like ours this evening doesn't get translated into some other iteration years down the road because there's no plan attached to it as to what in the side yard was varied?
I'm trying to remember what they look like. Jay, you may know more than me. I thought they were just a form, and it said, you know, the date the variance was granted, the particular zoning regulations which were varied. It might have said the purpose of the...
No, it doesn't. No, it just cites the regulations for which the variance was sought, from which the variance was sought. And I believe the applicant, which, I mean, it's really, the applicant is irrelevant.
It would be my suggestion for perhaps the two gentlemen to discuss further that there's a benefit, in my opinion, of having these resolutions cite the reference plan that has been approved that night, so there's some documentation going forward in time to reference, you know, what it was that was actually varied.
It might cite it might designate an application number or something. Do you recall that?
I don't offhand. I'd have to take a look.
Yeah,
but
I don't recall either.
And another way that I know some towns do that is in the approval letter that's issued from the zoning office, they'll say the variances are approved as per plans at the subject hearing, which I know some departments feel that binds the variance to the plans that were presented that night.
Could I respectfully request you explore incorporating something like that for this board going forward?
Absolutely.
And I don't know if the chairman needs to make this request, but could we get a legal memorandum from the town attorney's office at his convenience that gets us up to date on current law as represented by the state of Connecticut Supreme Court on the granting of variances and what has to be demonstrated?
Yes, we can do that for you.
Thank you.
Okay. The other things you guys do, variances are by and large the bulk of it, but you may have come across this already. Our statutes allow an appeal to this board from a decision of the zoning enforcement officer or the planning and zoning administrator. So if somebody feels that a decision was made, such as a location approval was approved, or I don't know, the certificate of zoning compliance was granted, and they feel that that was erroneous, they can appeal that to this board. When that happens, this board sits in what we call a quasi-judicial capacity, and it's your job to interpret the zoning regulations at that point in time. The zoning enforcement officer is going to have his or her point of view, but the argument made to you will be that that decision that was made, that act that was taken, does not comply with the zoning regulations, and they'll argue that to you, and it's up to you to determine that. Where you find that the zoning enforcement officer has made an error, then it's incumbent upon you to state your reasons on the record for that. And so that's probably the second most common type of application you're going to get. Third one is, there are certain location approvals, specific location approvals that you may have to grant. And in those few that come before you, your job is to assess the specific statutory criteria required for that location approval and make a determination as to whether the application in question meets that statutory criteria. But by and large, variances are going to be what you deal with most of all.
Any more questions?
Thank you.
Thank you very much.
Okay.
Okay, we have any other, we need a motion to close the administrative session. Motion to close, Mr. Fedett?
Excuse me, I'm not sure of the procedure, but do we have to approve the minutes of the last meeting?
Oh, okay, I forgot about that. Okay, what do we got here? Where's my agenda? I got one page in my agenda. Okay. Okay, I got what are we doing with this?
Those are the minutes that we are approving.
Okay. I need a motion to approve the minutes for May 3rd, 2000. Mr. Fedett, second. Mrs. Young. All those in favor?
Aye.
Aye. Okay, anything else? New business, old business?
Jay, can I ask a follow-up question to what we heard from the town attorney? And bring him back up
Sure.
if you don't know the answer. For those applications that have a coastal site plan element attached to them, it's my understanding, but I wonder if it's shared here in Stratford, that findings need to be made by the board alongside any finding of hardship about consistency with the coastal area management policies of the state of Connecticut, if and when granting an approval that has a CAM component attached to it. Is that your understanding as well?
I share that same understanding, yes.
And if you see us go awry, forgetting that element, if it's applicable, will you kick us or otherwise motion to us to include that?
I will.
Thank you.
Okay. Our next agenda, next month's agenda, you want to include that so we can vote on it?
Sure.
Okay, thank you. Okay, motion to close, motion to adjourn, I mean. Mr. Fedett, second by Mr. Wojcik. All those in favor?
Aye.
Aye. Thank you very much, people.
I don't think the rest of these people know the meeting's over in a half hour, but...